yes, I think a person should hire an attorney immediately. In fact, not just a lawyer, but a CPA and other professionals to make sure that the business entity that the person desires to open is formed properly with the state and that it meets the state guidelines, whether it's a professional limited liability company, a limited liability company, or a corporation. And making sure that all the legal documents are properly set up to ensure compliance, and then making sure that the taxation side of it is set up properly as well. So engaging a lawyer from the very beginning is important to prevent other regulatory issues as well as non-compliant issues, and just setting the tone for their overall startup. So I think a part of the creativity and the brainstorming needs to be a part of the initial meeting with the attorney. What is this company going to do? How are you going to market yourself? Do you have a logo? Where is your physical presence? Are you just the state of Florida? Do we have the licensure we need if it's licensing, required? And so those things can be very helpful. Also, I think when clients realize at that initial meeting, once we diagnose what's the best entity and the taxation structure, they'll realize that spending money on a lawyer, which is usually a flat fee situation and a filing fee, was valuable in that they're going out and hiring these third parties. They may spend more money and not get the setup correctly. So assuming the business is set up properly, first of all, with the proper legal documents. Anytime there are partners involved, other than a husband and wife, even when it's family, it is critical to have those operating agreements if it's a limited liability company, or bylaws or shareholder agreements if it's a corporation, because that agreement is going to dictate what we do if someone dies, what we do if someone goes through a divorce and that interest is going in that company through that particular person's divorce proceeding, or if one of the members or shareholders files bankruptcy. So what we do as business owners in our personal life could affect that interest in the company. So having legal documents set up to provide that roadmap of what we do in this scenario, like a buyout, is critical. So to me, the most important fundamental reason a business can be super successful is being set up properly, both legal and tax. And then during as you mentioned, during the lifespan of this wonderful business, making sure that they have proper contracts, that they are in compliance with HR with employees, that if they sell a product or they provide a professional service, that they have certain assumption of risk forms or consents to treat, or with food or different things, food and beverage, if there's any type of particular disclaimer that needs to be put on the wall. Those types of things can help businesses to stay out of litigation, avoid lawsuits for like wrongful termination or any employee-based issue. Really, a business needs a toolbox of professionals: a lawyer, a CPA, a good insurance person dealing with workers' comp, any of the insurance for benefit purposes, general liability, as well as other individuals to make that business successful. By having that team together, we'll avoid potential issues. So it really depends on the client and the attorney. Under the Florida bar rules, if we are undertaking representation in a general capacity versus, both with general or specific, like if I'm drafting up an employment contract for your business, you would call me up and I'd say, oh, that's going to cost you $500 to do that employment contract. I'll have it done for you by Friday. No problem, Kerry Anne. That's a one-time thing. But really, depending on the relationship and the history, I will rarely have a client do retainer. When I used to litigate, that was required. But with just transactional documents here or there, or a phone call here or there, most lawyers probably will not require that. I don't. And it really just kind of depends. I represent a lot of business in our 4-county area, and many of them just have me on call when they need me. Or it's very specific, like, hey, like Friday I drafted a employment contract for a dental office in Pensacola. So I drafted that. I'm drafting that contract, they'll review it, and then I may not talk to them for a while. But having that attorney that they know that they can email me on a weekend if it's a crisis situation, and I can guide them like, oh, we need to put the carrier on notice, or don't do this, or how do I handle this? It's very important to have that phone call ready to go and that lawyer to be able to pick up without having to schedule an appointment for 6 weeks. So once again, getting set up properly from the very beginning, that you have all your toolbox where you can just pick up the phone call and call that attorney, because there's a relationship, is really important and highly recommended. Yes, absolutely. It really comes back to the fundamental, what are your documents? Because let's say you have John and Sarah and they're business partners in a construction company, and Sarah has a different feeling about something, John has a different feeling. Well, in the event that they cannot decide and there's tension there, we go back to what are the legal documents? Who's doing what? And I'm a big fan of stay in your lane. You know, when you do legal documents, what's John gonna do? What's Sarah gonna do? Do the legal documents indicate that? Because the second one person feels that they are not being treated properly, or that they're doing all the work and the other business partner's not doing it, and then there's a disparity between, well, I'm doing all the work, you know, but John is not, but John's getting paid what Sarah's getting paid, that's when a lawyer is called. And having key employees to keep the business partners out, so that there's some more transparency and more ability to say that, oh, that's Bonnie's job. She does all of the accounting. So this is what Sarah's getting, this is what John's getting, to where you have third parties to keep the relationship together. I think where businesses fail at the dissolution or the startup or during the business is when there is this distrust. And the distrust is based on, you're not doing what you said. You were going to stay in your lane and now you're out of your lane. And you're not doing the work that accurately represents your compensation. And I can't tell you, daily I get phone calls throughout the state on those issues. So we go back to, well, what did John and Sarah agree to? Well, then what? Then John is not following the rules. And maybe we can save the relationship where the business is not having to be dissolved and liquidated, and maybe a bankruptcy filing if we have debt that exceeds certain assets, because the two of them don't get along. That's probably the best advice I can give, is getting everything set up, having policies in place so no one's feelings get hurt on what I'm doing versus what you're doing. We all know that sharing money together or sharing space together can be hard, because we all have different feelings, different wants, different expectations. But if the fundamental documents accurately identify what those rules and responsibilities are and how the compensation, then feelings cannot be hurt.